The enactment of Finance Act of 2019 and 2020 paved the way for Nigerian government to improve the country's tax landscape. In furtherance of this objective, the Minister of Finance and Budget and National Planning, Mrs. Zainab Ahmed, a few months ago approved the Tax Appeal Tribunal, TAT, rules for 2021. The rules, which replaced the defunct TAT procedural rules of 2010, enables the tribunal to deal justly, fairly, and expeditiously with tax appeal. They also encourage and promote the settlement of disputes among parties. In addition to the amendment of the TAT rules, which is the forum of first instance for formal tax adjudication in Nigeria, aligns with changes in global tax administration systems. These new rules have ensured that TAT procedures are up to date and are meant to give taxpayers increased confidence in the system. However, some experts are of the view that the Minister of Finance should consider making the rules less litigious or court-like to ensure that TAT maintains its edge as speedy and non-litigious tax dispute resolution forum. So to enlighten us on this new TAT procedure rules and their significance for dispute resolution, we are now being joined by Kenneth Erikume, a tax expert and partner at PricewaterhouseCoopers, Nigeria. Good morning, great to have you. Let's talk about this because, I mean, there are many cases as regards, tax litigation on ground. I mean, the famous one is out there, as regards a media company and the tax authorities and all of that. And this sort of authoritarian stance they take. They say it's what we slam on you, you take, you have to pay a penalty first before you even talk to us in the first place. So there's been a lot of pushback as a result of that. And when you look at it critically, a lot of people say it's because the rules are not defined. That's why people don't want to pay taxes. And that's why Benin Republic, for instance, has tax adjudication of 15-16%. Nigeria has less than 8% of that. What is happening?
Yeah, so there are actually two things that has created a bit of a bottleneck in terms of revenue generation in Nigeria. There are many, but two main ones. The first one is the trust issue. When I pay my taxes, do I have confidence that government will use the taxes judiciously in providing goods and services for citizens? There is a second one which I'll touch on later, which is at the heart of these new TAT rules, which is the confidence or the trust within the tax administration system itself, where the taxpayer is confident that when they pay their taxes, and comply, they will not be harassed. In addition to that, what you see playing out, especially in countries that do not have a well-developed tax administration system, is that a few people contribute to the tax pot, while a lot of people, are outside the radar. Unfortunately, Nigeria is sitting in that sort of scenario currently because the tax administration system focuses on a few companies and tries to milk as much as possible from those taxpayers. In addition to that, there are complications in our fiscal structure, which makes it a bit difficult just by the nature of the structural problems that we have. In many countries, for example, the most difficult tax to collect is the personal income tax, which is the tax on individuals, because chasing after human beings is quite difficult. Usually that is administered at the federal level in most countries, but in Nigeria, it's administered at the state level. So the contribution to personal income tax from a Nigerian perspective is very low. While in other countries, you pick South Africa as an example, personal income tax contributes the most revenue to the tax pool. So these are some of the issues that we have in the tax system. But it's interesting to note that one of the things that happens with a tax system is that, if you're a taxpayer, as much as possible, you want to optimize your profit. The tax authorities, on the other hand, they have an agenda or an objective, which is to collect as much as possible from your pocket. Of course, this is, these objectives do not really align. And that's where you then have tax disputes, and where the Tax Appeal Tribunal is very instrumental because, it turns out cases very quickly. And one of the things we would obviously commend the Minister of Finance for was, the speedy, she put up the tribunal not many years after coming into office, and immediately, tax cases were then being heard, and decisions were coming out. But these new rules, there are good parts, as you rightly identified, to bring things in alignment with current realities, the use of technology, virtual hearings, so now with the new rules, you can actually, present your case before the tribunal using a virtual platform, especially if it's far from you. Of course, there's also the one where, there are, 6 areas where the tribunal has been set. So the tribunal can actually, you can take your case to the north or the south. But one of the things they've instituted now is that you can take it to the tribunal closest to you, even if the issue is being heard. For example, in the north, you can hear it in Lagos or submit in Lagos. As well as, you can file your applications or serve your notices electronically. But the big one is the 50% deposit, which you have to pay in order for your issue to be heard. And that's the one, I have a problem with.
Okay. The Tax Appeal Tribunal, that's the main thing we're looking at. And it's good you've looked at the highlights. Now, but some people have complained about conflicts with the TAT procedural rules of 2010. That's one. What are those areas of concern, the challenges ahead? Because it's not enough to just say, okay, you can do virtual this, you can do that. 2, where does this leave the jurisdiction of the High Court, over taxation and revenue issues? Because, the Appeal Tribunal is supposed to deal with substantive issues, but now you have a litigious process because of the conflict with the TAT procedural rules, which has not been technically replaced in the real sense.
Yeah. So the big issue, the big problem with the new procedure is the fact that it instituted a requirement that you have to pay a 50% deposit of the disputed tax before your matter is heard by the tribunal. Obviously, that is creating a bar against fair hearing or the right of taxpayers to be able to present their case for proper assessment by the tribunal. I'll give you a classical example. In 2017, there was a company called Acacia Mining. And in Tanzania, the Tanzanian Revenue Authority issued a tax bill of $190 billion on that company. If the company had to hear their issue, if it was Nigeria, they would have had to pay $95 billion in order for their case to be heard. $95 billion, if I pick Dangote refinery, that's about 5 Dangote refineries. Now, if as a taxpayer you have to pay that in order for your issue to be heard at the tribunal, of course, that is creating a bar for people to get justice. Eventually that issue was actually settled for $300 million. So you see there that there, if these rules are applied as they currently are, it means that there'll be a lot of companies that will be disadvantaged because they cannot take their issues to the tribunal. It means that the tax authorities will be in a stronger negotiation position, and they may even abuse that opportunity because they can issue assessments of any amount, knowing that before you even get the matter to the tribunal, before the tribunal hears you, you have to cough out that amount. And for me, that is fundamentally wrong because it goes, you rightly identified, it goes against the FRS Establishment Act, paragraph 15 of the 5th schedule, which says that, you pay a deposit of either 50% or, last year's, the last year of assessment's tax liability, the lower of the two. And there are conditions before you even pay that deposit. It's either, the person has not been filing tax returns, or the appeal by the taxpayer is frivolous and vexatious. So what that means is that, the person is just trying to abuse the whole process. And of course, the final one is if it is expedient for the tribunal to ask for a deposit. But these new procedures ignored all of that and clearly contradicts that. But from a legal perspective, I mean, it's clear that when there is a rule or a regulation that contradicts the substantive act, the substantive act should prevail. So overall, I think, even though they have put this new rule to pay 50% deposit, the FRS Establishment Act would be what should be enforced at the end of the day, because that is what is fair, and that is, similar to what you find in other jurisdictions.
Well, that it should be enforced does not mean it will be enforced. So how do we go about expunging that contentious Order 3 Rule 6, I believe it is,
Order
entirely?
3 Rule 6, yeah. So how do you expunge it? Obviously, one of the avenues is what we're having a discussion on the issue. So it's out there, so people are aware that this issue is out there. Unfortunately, I do not, and you're right, I do not see the tax authorities interpreting the rules the way I have interpreted it, that the FRS Establishment Act would override that. Unfortunately, it's out there. The Ministry of Finance has put it out there. Companies would have to enforce their rights and say, this is not right. And I think the organized private sector would be instrumental in playing a role in that area. So, there are many things that, the likes of NECA and others have taken upon themselves, to come up with a position. I think this is one of those fundamental issues that I think the organized private sector needs to tackle, because we need to build a tax system that taxpayers can trust. Apart from the trust which we have in government using our tax revenue properly, we also need to have trust in the tax system. In some jurisdictions, if you overpay taxes within a few days, so when I practiced tax in South Africa and I did my tax return, I established a refund. Within 15 days, my refund was paid to me. In Nigeria, to get a refund is almost impossible, but it's in the law. And those are some of the things we need to tackle as citizens of this country.
So, a lot of people, this is their position on this law. It's authoritarian, and they say the tax authority bandy phantom figures. And they just put it on the table and say, pay 50% of that before you start the negotiations. And I also want you to talk through how it affects the economy, because I followed that. In fact, I had interested parties in that case in Tanzania about Acadia mining. The other part you didn't say was it was Magufuli trying to fight what he called the imperialists, the then president of Tanzania, and how that impacted foreign direct investment in Tanzania. The numbers dropped big time afterwards.
Absolutely.
And it affected the Tanzanian economy.
Absolutely.
And we're beginning to have that here too, in return.
Yeah. Yeah. So I mean, it's something that we need to tackle. So you're right. The share price, the stock price of Acacia Mining dropped, I think, about 15% immediately the announcement was made. And in terms of the profile of the country, obviously, investors would become a bit apprehensive and be more cautious about, investing in that sort of country. So clearly it's a place where we do not want to go as a country. But the reality is that, even without these TAT rules, the revenue authorities will try as much as possible to encourage them to be professional in terms of approaching tax assessments. But we see ones, here and there sometimes, that they always come up with significant assessments, frivolous assessments, if I can use that word, before the taxpayer engages. So sometimes, so there was a company that was carrying out a due diligence on a Nigerian target because they wanted to acquire a Nigerian company and invest. And one of the things they saw, when they started, reviewing the company was there was an outstanding assessment from the tax authorities. And this was going into hundreds of millions of dollars. And it was a chore for me as a tax professional to tell them that this assessment is just, the first step of the whole process. That what we see most times is that, the FRS or the state tax authorities come up with something significant first, because the first thing they're trying to do is to come from a place of negotiation where they feel they're stronger. And then when you're using principles to argue your position, they will tell you, but we have given off, we have already dropped this thing by 30%. So why are you still arguing? So those tactics, those things we're hoping that those things drop because, they have the potential of disrupting and creating a bad image, for the country. So I'm hopeful that, as we continue to engage and we continue to put these, conversations out there, assessments become a bit more realistic and people can then engage at that level where it's based on principle, but not just on numbers that are being bandied by tax authorities versus taxpayers.
Well, I asked you a question earlier, which I don't think you got to, which is the jurisdiction of the Federal High Court with regard to revenue and taxation issues. Because the tribunal, tax commissioners, are not supposed to act as judges. Whatever they come up with is supposed to be preparatory or supplemental to, a proper court of competent jurisdiction looking at the matters. Is there any conflict here?
Yeah, there have been cases historically of people challenging the jurisdiction of the Tax Appeal Tribunal. Because when you look at the Constitution, it's clear that when there are issues around revenue of government, that should be escalated to the High Court.
Federal High Court.
Yeah, so if it's a federal issue, it goes to the Federal High Court. If it's a state issue, it goes to the State High Court. But in the past, some cases have addressed this issue and have agreed that, the Tax Appeal Tribunal is a quasi-judicial forum for taxpayers to take their issue. And, if at that level, both parties agree on the settlement terms reached by the Tax Appeal Tribunal, then, parties can rely on those judgments. So the Tax Appeal Tribunal still has a role to play. It's like, if you agree that it's not a court, you can agree that it's like an arbitration, procedure where parties can say, let us go to an objective panel to review my argument and yours. And then if they favor me, then let us agree that, you drop your liability. If they favor you, then I'll pay the liability. But if we both do not agree, or one of us does not agree with the outcome of the tribunal, then we can take it to the Federal High Court. And if we still don't agree at the Federal High Court, we can escalate even to the Supreme Court. And there are many tax cases that have been escalated that way. The benefit of the tribunal is that it's specialized because they only address tax issues. Which gives it a bit of an edge because they're able to understand, by reason of experience, many of the issues that are being taken there. So it still has a role to play, even though there are, some lawyers and some judges will tell you that, once it hasn't gotten to the Federal High Court, then, the judicial process hasn't even started.
Yes. Yes. So.
Well, apart from foreign investment, what is the impact of this Rule 6 on employment? Mm-hmm. What kind of impact could it have? Take us through that, because we have our tax bodies, their income, their revenue-generating bodies. They have targets that are given to them. Yeah. And in the course of trying to meet those targets, what are the dangers to businesses and our unemployment rate? Can you imagine if Acacia Mining had to pay 50% of $190 billion? So obviously they wouldn't have had it in their bank accounts. If you recover their assets, it wouldn't have been able to pay the taxes. So the only thing you would do is, if they can't pay the 50% deposit, if it was Nigeria, is that they would shut down
and then all the staff would pack their bags and go home. And I don't think that that is the way to actually approach disputes. The reason why you bring an independent arbiter to look at the issue is because there would always be disputes because our objectives are not aligned. I'm trying to optimize, if I'm a company, I'm trying to optimize value for shareholders. Tax authority are trying to optimize value for citizens, hopefully, which many people don't trust. Because at the end of the day, it goes to government, and government is supposed to use it for the people, pay salaries, infrastructure, and all that. So there is a bit of misalignment, and that will always create dispute. What you do not want is that, in order to hear my case, remember that I have no control over the tax authorities and the position they are going to come up with. As he said, they can come up with something very significant. I need to be able to take my issue without dropping a penny to an independent person to actually, cross-reference and think about the issues and come up with a position. So if we apply the rules without recourse to the FRS Establishment Act, which says this should not be the case, and the tax authorities push this agenda of 50% deposit before hearing matters, I'm telling you, it's going to be very disruptive for the economy. It's going to impact on employment. It's going to impact on investment. It's going to also impact on, how issues are actually settled because there'll be no trust.
Yeah.
Remember that the tax authorities will then be coming to the negotiation table with a stronger hand, because they say, well, if you don't agree, we'll take it to the Tax Appeal Tribunal and you would have to pay 50%.
And does this also, because I've heard cases, many cases now, does this also involve, maybe the tax authority putting like a blockade on your accounts while this process is going on?
Yeah. So the issue of blockade of accounts, this was very, very common, about 4 years ago, with the tax authorities writing to banks to say, post no debits on this account, and it's essentially frozen, which means you cannot do business.
They're doing it.
Yeah. So there are, based on the laws, there are ways they are supposed to do it. The way they did it in the past was very wrong. So the way they did it in the past was they would take the credits into the bank accounts and assume that all of that was income. Remember that credits into the bank account could be loans. It could be transfer from Zenith Bank, sorry, I'm using bank name, from Bank A to Bank B, which is an internal movement from one pocket to another. So there's really no income if you're seeing a credit in the bank account receiving it. And then they now said, 5%, then the tax VAT rate was 5%. 5% of it is your VAT liability. They now look at how much VAT you paid, and if there's a difference, they say, there is outstanding tax. They did the same thing for CIT. And based on that, without issuing assessments,
You just swap everything.
they just wrote to the banks, and said the banks had to freeze the accounts. Some banks engaged. But you remember, many of these banks, they are cross objectives. So number one, obviously they have regulators. Number two, the government is also a significant customer. So many banks went ahead to freeze the accounts. But the way it's supposed to happen, the assessment has to be issued by the tax authorities first. The taxpayer is supposed to have 30 days to respond. If they do not respond, then that assessment becomes final and conclusive. Only then should the accounts of the taxpayer be frozen. And it's not freezing. What the law says is that you appoint the bank as an agent to recover the taxes. But what they did then was, let's assume they even came up with, wrongly, they came up with an assessment of 20 million naira. They would write to 10 banks and say, this person owes 20 million, you have to freeze the account, which means that when you multiply 20 million by 10, you would have essentially frozen 200 million for a 20 million liability.
We'll have to go, but I think the big issue is about that 50% deposit rule. which is considered by many as an unfair structure.
Absolutely.
And I hope that someday somebody will go to court to challenge it.
Absolutely.
Thank you very much for joining us.